Hello and welcome to Take from Caesar. My name is David Merlin. This is another installment from the Codebreaker curriculum, my analysis of the tax code that was complete in 1994. The document we'll look at first is about the non-resident alien argument. This is an excerpt from a memorandum written by Chief Judge Voorhees, US District Court, North Carolina, in 1992. You see in the third paragraph there's a 1995 case cited. I put that in there. The memorandum has a couple of slight alterations, but this is a 1992 disposal of the non-resident alien argument under Tax Code Section 861 by a U.S. District Chief Judge. That's 22 years ago. This argument is the one that saw Wesley Snipes go to prison. It's always been rooted in haste and negligence, and you can count on the quote-unquote movement for little more than that. The memorandum here on the non-resident alien argument can also be found on takefromcaesar.us on the blog page. And we're not going to read every word of this, but I wanted you to see it in this video because this particular lesson is probably, likely the single most damning argument against the application of the tax code to Americans that's ever been crafted. What you'll learn in this video is the key to the code. It's the reason the video is named Key to the Code. If you stand at a distance back from the tax code and look very closely at it before you allow the government to drag you into its provisions, there are certain things at the very foundation of the scope of the tax code that I'll teach you, and at the end of the course you're going to see proof that it gives the government fits. Now, the non-resident alien argument, in 1992, 22 years ago, I met a real nice couple from North Carolina who very well may have passed on by now. I know they were up in age, and they had gone before the court with a petition or lawsuit to quash an IRS summons, and they had 9 arguments. North Carolina is a sovereign state. We're non-resident aliens. To Washington, D.C., we're not receiving kickbacks. The summons doesn't have an OMB control number. The officer from the IRS, Officer Kreitzel, hasn't been delegated authority to perform this function. And even if Officer Kreitzel had, they aren't of a high enough grade level to perform the task. The regulations under the tax code only apply to 27 CFR, which is Bureau of Alcohol, Tobacco, Firearms. They made a blanket Fifth Amendment objection to answering any and all questions. And the judge briefed away each and all of those arguments. There was a couple others I can't remember. And in that 45-page memorandum was an entire education on a couple of major points. Number one, how to cite cases. How to utilize running footnotes, and how to brief your way out of a challenge. In 45 pages, 9 issues briefed into oblivion, unless you feel that you're the sort competent enough to go up against a U.S. District Chief Judge. And what you see here is his memorandum on North Carolina is not a sovereign state for the purposes of the tax code, and you are not a non-resident alien for the purposes of the citizenship that can be taxed under the 16th Amendment and Congress's taxing authority. Top of page 1, in a verbose complaint with numerous attachments, petitioner contends that his constitutional rights have been violated. Petitioner seeks a temporary restraining order, permanent injunction, and $25,000 in damages alleged for perjury on the part of the IRS's employee officer Kreitzel, allegedly in the form of Kreitzel's statement regarding the citizenship of the petitioner. Now, I reduced this to a single petitioner. It was actually a husband and wife. And I Joe lunch bucketized the pleading for the purposes of this memorandum to keep their names private. He has filed a financial affidavit and seeks to proceed in forma pauperis. When considering a complaint accompanied by a motion to proceed in forma pauperis, a district court may rule that process should not be issued if the complaint is malicious, presents an indisputably meritless legal theory, or is predicated on clearly baseless factual contentions. Indisputably merit legal theories are those in which either it is readily apparent that the plaintiff's complaint lacks an arguable basis in law, or that the defendants are clearly entitled to immunity from suit. The United States Court of Appeals for the Third Circuit has stated that the plain meaning of frivolous authorizes the dismissal of in forma pauperis claims that are of little or no weight, value, or importance, not worthy of serious consideration, or are trivial. It also has been determined that the frivolous determination is a discretionary one, and trial courts are in the best position to determine when an indigent litigant's complaint is appropriate for summary dismissal. After consideration of the application to proceed in forma pauperis, the petition, and documents attached, the court concludes that the action is frivolous. Federal courts, as a general rule, are unwilling to disrupt state court proceedings, as in the instant case where petitioner, in addition to his request for damages, also seeks injunctive relief. Adherence to this long-standing principle yields the conclusion that petitioner's complaint fails to state a claim upon which relief may be granted, lacks an arguable basis in law, and therefore the action shall be dismissed as frivolous. Top of page 2. Upon due consideration of petitioner's claims purportedly arising out of provisions of the Internal Revenue Code and over their perceived constitutional limitations on federal authority in the several states, this court has concluded petitioner's complaint is frivolous and without merit and should therefore be dismissed. North Carolina as a foreign state. And the judge gets into it. And again, we're not going to read every word of this. It's available on takefromcaesar.us on the blog page. Read it at your leisure. I feel when the judge gets into the case law, specifically the Slaughterhouse case, I feel he takes it slightly out of context, but not to a fatal degree. And here's his argument, how North Carolina is not a foreign state for the purposes of the taxing authority exercised through the enactment of Title 26. I'm on page 2, the second paragraph under the heading North Carolina is a sovereign state. Notice that he cites the North Carolina Constitution, Article 1, Section 4. Every citizen of this state owes paramount allegiance to the Constitution and government of the United States, and no law or ordinance of the state in contravention or subversion thereof can have any binding force. I'm on page number 3. On page number 3, near the bottom of the text before the footnotes, you see the sentence, such claims as to limitations on federal powers have repeatedly been struck down by the courts. Footnote 3. I added footnote 3 to this document. Footnote 3 is enormous. As you see, page 4 is taken up entirely with footnote 3. Footnote 3 is Lowell B. Craft's work on frivolous claims, mostly non-resident alien claims. Page 5, petitioner's non-resident alien status. And the judge gets into it. You see the first statute of note is Tax Code Section 865. 1, 2, 3. Petitioner has failed to produce evidence demonstrating he is indeed a non-resident alien. First, as to petitioner's citizenship, the record is void of evidence showing the petitioner was born or naturalized somewhere other than the United States, meaning we presume him to have been born in the United States. Second, petitioner's declaration of status does not constitute a voluntary and intentional relinquishment of the United States nationality. And third, page 6. Third, petitioner has failed to satisfy the lawfully admitted for permanent residence, substantial presence, or first-year election residency test under 7701B1A 1, 2, and 3. Thereby precluding his qualification as a non-resident alien individual. Then the judge gets into Section 871. And this is in direct refutation of the lawsuit filed by this couple that sought to quash an IRS summons. Page 7. I wrote this because the language of Section 861 itself is contrary to the allegation that the services of a non-resident alien are not taxable, or the compensation is not taxable as gross income. And we aren't going to read this, but as you read it, when you go to takefromcaesar.us, go to the blog page, read this memorandum. This is the third issue, issue C, sources of gross income, and try to tell the difference between my writing and the District Court Chief Judge Voorhees' writing in issues A and B. Compare them closely, and you understand why I pointed out this is a U.S. District Chief Judge, and unless you can write on par with a District Court Chief Judge, don't try it. They'll humiliate you. And when I write, I always write to this level of competence. It's a necessity. I know that when I write, when I submit a brief, the Department of Justice immediately knows that they really have to work hard to rebut. They usually know it was Dave Merlin that wrote this brief, because you won't find many people that write on par with this particular writing style. Page 8. We have the language of Section 861 right there in the middle of the page. In the middle, compensation for labor or personal services performed in the United States shall be gross income, except that compensation for labor or services performed in the United States shall not be deemed to be income from sources within the United States if performed by a non-resident alien individual temporarily in the United States. He didn't make any argument that he's temporarily in the United States, and that's the only thing exempted by Section 861. I scroll. I'm on page 9. Look at the bottom paragraph, page 9. Petitioner complements this claim with the traverse that the tax is not imposed by clear language, as due process would require, and that this is sufficient grounds for nullification of the respondent's determination of tax liability. This court agrees that a tax must be imposed by clear and unequivocal language. Where the construction of a tax law is doubtful, the doubt is to be resolved in favor of whom upon which the tax is sought to be laid. The court finds that the language, and I'm on page 10 now, the court finds that the language of Section 861 meets its burden of clarity under that, and that under its terms, Congress has not excluded from gross income the compensation received by the petitioner in exchange for his personal services. I had this memorandum, issues A and B, in 1992. There are still people prescribing that you make this argument, that you file 1040 NRs, writing books, publishing curriculums, putting websites up that say you're non-resident alien. This is 1992. Look how many years after that. Wesley Snipes went to prison on this. Larkin Rose, Eddie Kane, Lynn Meredith. I think Pete Hendrickson claims that you're a non-resident alien. In the memorandum from, and I use the term memorandum loosely, from Joe Bannister, 17 pages, where he mostly regurgitates a bunch of stuff that other people were teaching. Doesn't appear to be research of his own. 17 pages. Everybody concurs on this argument when in 1992 I knew it was nothing I wanted to say. Anyway, we're going to move on to the next document. The reason I included this is to show you what I'm not going to argue. We are going to get into citizenship, but we're not going to get into my citizenship. We're going to go with the flow. The government says, you're a person born or naturalized in the United States and subject to its jurisdiction. You're a citizen of the United States. Sure, that's me, if they say so. And rather than look at that definition of citizen and say, no, that's not me. I'm not subject to its jurisdiction. I'm a non-resident alien individual. I'm going to look right at that definition of citizen and say, I'll be that citizen. And then I'm going to launch my argument based on the citizen they call me, but not by rejecting their definition of citizen. I'm going to do it by accepting their definition of citizen, which I hope you can appreciate on its face is a totally different challenge than the non-resident alien argument. Totally different. This is where the demise of the tax code takes place, is when you accept momentarily or permanently, it doesn't matter, when you accept their definition of citizen, it's all downhill from there. The wagon starts rolling in your favor and it can't be stopped. I've gone on to the next document now, page 1 of 26. Look at the top of the page. Issue. Citizens of the United States, like me, are implicated as subjects of 26 U.S.C., the tax code, income taxes, by regulation alone, in violation of the 16th Amendment. 16th Amendment, you'll recall, says Congress can lay and collect income taxes. It has to be a statute. And I've just alleged that my issue, the issue I take, is that I'm going to object to being implicated by regulation alone. On page 1 of 26. This is, for the most part, a copy and paste from an existing memorandum. I filed with 80 members of Congress December 28th of 05. We'll call it January 1st of 06. New Year's of 06. 80 members of Congress received a 180-page criminal complaint that included a memorandum, a 33-page racketeering and extortion complaint, several exhibits, an 8-page table of authorities, a 7-page certificate of service, a cover letter of 12 pages that was notarized with a couple of exhibits out of my personal file, me and the IRS going at each other. And let's see, I think it was a 10-page abstract of primary claims, declaration of truth as to the accuracy and veracity of the exhibits, other than specifically enumerating the exhibits. That was it. So 180 pages, went to 80 members of Congress with photocopying, notary, and postage, all told almost $6,000. Why would I do that? Well, in May and June of 2005, the IRS pulled a particular stunt on me. They sent a notice of change to your account. Your account status has changed. For activities after October 22, 2004, we hereby penalize you for promoting abusive tax shelters. We've penalized you under a statute that says we can either penalize you $1,000 or we can penalize you 20% of what we think you would have made off of your efforts. Amount of penalty, 1 penny. Credit to your account, 1 penny. Amount you owe, 0. Please don't send a payment. If you want to challenge this penalty, you can sue us in US District Court within 60 days. And then they did it again a month later. 2 1-penny penalties that they paid for me and told me not to send a payment and invited me to sue in US District Court, which would cost $350. So let's look closely at that. They take away my incentive to sue altogether. Penalty of 0, who's going to complain? And I got to thinking, they never do anything without a reason. And I figured out that they were going to go to a grand jury later and try to get me indicted for conspiracy to defraud the United States by telling the grand jury, you know, we penalized him twice and he didn't even complain. So the last thing I wanted to remain was a person who failed to complain about those 2 1-penny penalties. So I attached both of those as exhibits to my cover letter on this 180-page complaint that went to every member of the House Judiciary Committee, the Committee on Government Reform, and the Joint Committee on Taxation, and Ron Paul. January 1st of 06. It had a 58-page memorandum which briefed this issue as Issue A. First things first, before you drag me into the code, I want to prove that you can't. My other arguments were inside of the tax code, with the understanding that I don't want to argue inside the tax code until I lose my argument that's outside the tax code. It's a matter of gravity. I first want to bring my biggest arguments to bear, and then lesser arguments thereafter. Okay? Very simple approach. I don't want to wait till the end of my brief to say none of this even applies to me. It's the first thing I want to prove if I think I can prove it. I think I can prove it. And so the first 16 pages of that 58-page memorandum, there was an introduction. So Congress knows where the issues have been. I've had it in court a bunch of times, and they don't know what to say. These are assistant U.S. attorneys in the tax division. They can't talk about 5 or 6 statutes. And when you narrow it down to that few and you hit them with it in a certain structure, a certain line of reasoning, and you watch them run from it, as you're going to see at the end of this lesson, I hope you can appreciate that this is pay dirt. This is the way the tax code was always supposed to be argued. In 1988, when the IRS initially ticked me off, I was like the world's second fastest bartender. If you're the fastest, you don't try as hard, so I'll say second fastest bartender. 6'3", 175 pounds. I could dunk basketballs, got long arms, big hands, a great memory. I was made for high-volume bartending. And with the band playing, in 1985 and 1986, I was making $1,100 worth of drinks an hour on Friday and Saturday nights. So scary high volume bartending. And the IRS ticked me off. April of 88. June of 88, I started studying law, just tax law, for like the next 5 or 6 years. I didn't even look at another title of the U.S. Code, and made a few appearances as an expert witness in like 1994, completed my treatise at the end of 1993, and began litigation. The introduction to the memorandum had a bunch of docket numbers, has a bunch of docket numbers of where these issues have been, what the court's responses were, and none of them are satisfactory. It's all evasion, so I included those in my complaint to Congress. And after briefing statutory interpretation, the canons of interpretation for the first 15 pages, 16 pages of the memorandum, I then begin to argue my conclusions. This is the first conclusion that I argued, that if I hadn't been named in a regulation only, the tax code wouldn't even apply to Americans. That's my first argument. And this is why I stated in the beginning of this lesson that this is probably the argument of the most gravity. This is the way the tax code has always supposed to be argued. When I went into the tax code, I just wanted to verify that the IRS could do what it was doing. I had no notion that I'd actually prove something was wrong. I simply wanted to get into it far enough to prove that the IRS was right or the IRS was wrong with what they were doing to me, because I didn't like the way I was treated. And I kept studying and kept studying, found more and more wrong. I found more and more things that the IRS was doing that the tax code didn't provide for. This is by far the biggest one. Section 83 is the second highest gravity argument, that the tax code acknowledges all property as a cost, which takes the value of labor from the profit column and puts it in the cost column. This argument is bigger. It takes the tax code and the IRS and pushes it back into Washington, D.C., where it can't get out. Now, we're going to start the lesson. I'm looking at a 26-page document in landscape format, meaning left to right is long, not like the usual page. And I printed it this way so it would all fit in the window as you view it here. But this is directly out of a supplemental briefing I wrote for the 58-pager. And what you're going to see is a multitude of case law in support of the argument that wasn't in the 58-page memorandum. It's just a slight extension, but the slight extension is blanketed, where you'll see that the argument has tremendous support in case law, coast to coast. I'm on page 1. Issue: citizens of the United States are implicated as subjects of 26 U.S.C. income taxes by regulation alone in violation of the 16th Amendment. There are only 3 chapters of the tax code we have to address. When you ask the question, do I owe a tax when all I do is sell my labor or derive capital gains from investments? Gains derived from dealings in property, dividends, the rest of it, all the capital gains, as well as compensation for services. Now, I know they take FICA out of my paycheck, Federal Insurance Contributions Act, Social Security, Employee, Chapter 21. I know that if I'm self-employed, they expect me to pay Chapter 2 taxes, self-employed, Social Security. And I know that I pay taxes on taxable income in Chapter 1, Section 63A. Taxable income means gross income minus allowable deductions, and then I go to Section 1 to pay that tax. So I'm double taxed. If I'm an employee, I pay Chapter 1 and 21. If I'm self-employed, I pay Chapter 1 and 2. Chapter 24, the W-4 form, doesn't even impose a rate of tax. So we can forget it. It's called income tax collected at the source on wages, but it's just about collecting an income tax that's imposed by Chapter 1. Section 31A at the end of the year allows us to get a credit for the W-4 withholding that we undergo all year long. So Chapter 24 doesn't impose a rate of tax. It imposes a method of collection to zero out at the end of the year with Chapter 1, where we either get a little refund or we owe a little bit more to the IRS. So they say. So I'm only concerned with Chapters 1, 2, and 21. Chapter 1, and then Social Security, be it self-employed or employee, in Chapters 2 and 21 respectively. So the first thing I've done with this explanation, this introduction, is to simplify the tax code. I just took away how much of it that we don't need to look at. We're just going to look at the provisions they say implicate citizens of the United States. That's all we're going to do. Simplification is key. It weighs over 20 pounds. The tax code and the regulations. I never weighed it. I never bothered to weigh it. I always said it was 25 plus pounds, 27 pounds, whatever, just to put an exclamation point on it. But it's over 20 pounds. It's like 15 inches of rice paper. 9.5 by 7 inches. It's enormous. But when you get down to the bottom of it and you concentrate strictly on the chapters that impose the taxes, work that nobody else has done, all of them jump into the middle of the tax code and begin with procedures and administration in the 6,000s, or they go into the 1440s, the 860s for non-resident alien argument, and they try to push the whole tax code off of them with one statute. I instead analyzed and discovered how the taxes are imposed. And there's enormous gaps in the scope of the tax code that show Americans have only been implicated through regulation, if indeed Americans are citizens of the United States. I'm at the top of page 1. U.S. versus Calamaro, 1957, states very clearly the challenge I'm going to make. I'm starting on the right-hand side of that first paragraph after it says Internal Revenue Code of 1954, 4 lines down. We find neither argument persuasive. In light of the above discussion, we cannot but regard this Treasury regulation as no more than an attempted addition to the statute of something which is not there. As such, the regulation can furnish no sustenance to the statute. The regulation is written by the executive branch. Tax Code Section 7801 and 7805 put the Secretary of the Treasury in charge of the IRS and says that the Secretary of the Treasury shall write all needful rules and regulations for the enforcement of the code. The executive branch writes the regulations. And this is about the Internal Revenue Code. And the Supreme Court just said, you can't do that. You wrote a regulation that adds to the statute. Look at the second case on page 1. See also Water Quality Association versus U.S., citing and quoting Calamaro. It is a basic principle of statutory construction that courts have no right first to determine the legislative intent of the statute and then, under the guise of its interpretation, proceed to either add words to or eliminate other words from the statute's language. See Lewis Sutherland, Statutory Construction. Lewis Sutherland on statutory construction is also cited as an authority in Hassett versus Welch, 303, US 303, which says that when one statute adopts the terms of another through reference, it is as if it had quoted that adopted statute in the body of the statute that adopts it at the date, the way the language stood at the date of the adoption. This paragraph goes on. Similarly, the Secretary has no power to change the language of the revenue statutes because he thinks Congress may have overlooked something. Our feet are on the ground of my argument. My argument is exactly this. Your authority comes from regulation. You can't do that. In 2000, we see at the top of page 2, you'll see that these paragraphs are numbered and they're not consecutive. Like I said, this is a copy and paste from an existing supplemental briefing. And I didn't take the entire memorandum into this document. So plenty of paragraphs were not brought into this particular document for the purposes of this lesson. Top of the page, page 2 of 26. Brown and Williamson Tobacco Company versus FDA. The tobacco company in the 90s said, under the Food and Drug Act, I can't see where the FDA gets any authority over tobacco. And yet they're going across the country to these convenience stores, citing people that sell cigarettes and penalizing them, monetary fines, for selling to minors. They'd send a minor into the store, 16, 17-year-old boy or girl. Hey, could I get a pack of Marlboros? And the store would sell them the cigarettes. They'd walk outside, and the FDA would walk right back into the store saying, that person's a minor. I want the videotape out of your cameras, and you're busted. $1,500. And the tobacco company said, under the Food and Drug Act, do they really have the authority? No. They wrote regulations to get that authority. We should sue them. And the Brown and Williamson Tobacco Company sued the FDA and said, in 1974, listen to all this stuff that the FDA told Congress about cigarettes, how inherently dangerous the intended use of cigarettes actually is. They kill people. And the tobacco company argued, if they did have authority over tobacco, based on what they've said in the past, they'd have to ban tobacco sales tomorrow under the Food and Drug Act. We allege that they have no such authority, that Congress has not yet given them the authority to regulate tobacco. District Court said, that's right. The government appealed. The Fourth Circuit Court said, that's right. And the government appealed. And the Supreme Court said, that's right. And so the tobacco company kicked the FDA's tail all the way up the line. And between the Fourth Circuit memorandum decision of 30-some pages and the Supreme Court's memorandum decision of 30-some pages, you read those two decisions together. They are the book on statutory interpretation, the gravity of regulations, the lack of power the executive branch has to meddle with the law when it writes regulations. Those two decisions right there are the book on interpretation and the gravity of regulations, what the executive branch can and can't do. The paragraph. In Brown and Williamson versus FDA, the Fourth Circuit and the Supreme Court rendered very lengthy memorandum opinions in decisions that stripped the FDA of tobacco enforcement authority, finding that it arose and was founded solely upon regulations promulgated by executive officials. Complainants claim, that's me in this supplemental memorandum, complainants claim that Americans, citizens of the United States, are implicated as subject to the tax code is identical in nature to the claims made against the FDA in that case. I'm saying, As a citizen of the United States, I am implicated solely through the promulgation of 26 CFR 1.1-1 in violation of the 16th Amendment, which authorizes only Congress to lay and collect income taxes. It has to be a statute that subjects me to an income tax. End quote. That's my claim. And now we're going to get into case law about statutory definitions. The definitions mean what they say. You can't, we already saw on the first page, you can't read something into a statute that's not there. You can't presume Congress forgot something. When you see a definition, you're out of luck if it doesn't include you. Or you're in luck if it protects you to be somebody that they pointed to in the definition. Metropolitan, that was an employer. Metropolitan was subject to Title VII, however, only if at the time of the alleged retaliation it met the statutory definition of employer. Statutes must be interpreted, if possible, to give each word some operable effect. We're going to read mostly the bold and italicized portions of these quotes. Thus, Congress did not reach every transaction in which an investor actually relies on inside information. A person avoids liability if he does not meet the statutory definition of insider. On its face, this is an attractive argument. Petitioner urges that in view of the severity of the result flowing from a denial of suspension of deportation, we should interpret the statute by resolving all doubts in the applicant's favor. I'm on page 3. But we must adopt the plain meaning of a statute, however severe the consequences. Footnote 3, J versus Boyd, 1956. These are Supreme Court decisions. Page 3, second. The wording of the federal statute plainly places the incident of a tax upon the producer, that is, by definition, upon federally licensed distributors of gasoline such as petitioner. The congressional purpose to lay the tax on the producer, and only upon the producer, could not be more plainly revealed. The statute has no provision making the vendee liable for its payment. Next paragraph. A purpose to subject aliens, much less citizens, to a police practice so dangerous to individual liberty as this should not be read into an act of Congress in the absence of a clear and unequivocal congressional mandate. I would hold that immigration officers are wholly without statutory authority to summon persons, whether suspects or not, to testify in private as witnesses in denaturalization matters. For this reason, I concur with the judgment in this case. Next paragraph. Conspicuously absent from 1415E3, however, is an emergency exception for dangerous students. This absence is all the more telling in light of the injunctive decree issued, which permitted school officials unilaterally to remove students in extraordinary circumstances. Given the lack of any similar exception in Mills and the close attention Congress devoted to these landmark decisions, we can only conclude that the omission was intentional. We are therefore not at liberty to engraft onto the statute an exception Congress chose not to create. Page 4. And as we go through this, I imagine in this video you can click on pause and see if we have enough resolution for you to read along and observe the cases cited in the footnotes. Top of page 4. It is axiomatic that the statutory definition of the term excludes unstated meanings of the term. As judges, it is our duty to construe legislation as it is written, not as it might be read by a layman, or as it might be understood by someone who has not even read it. If the term political propaganda is construed consistently with the neutral definition contained in the text of the statute itself, the constitutional concerns voiced by the district court completely disappear. That's Meese versus Keene, 1987. The definition of political propaganda they're discussing said the term political propaganda includes, and they still interpreted it as an exclusive definition. It excludes things not mentioned. Whereas we know in the tax code, when they see a definition that uses the term includes, they say, oh, it includes everybody. But especially the things that they mentioned in the definition. When in fact, this Supreme Court case interprets a definition that uses the term includes as one that's all-inclusive, or that's exclusive of things not mentioned. In the middle of the page, indented with respect to each of the legislative policy distinctions. Go to the end of the paragraph. We have no judicial authority to substitute our political judgment for that of the Congress. We hold that Congress, through the plain language of the statute, precluded this functional approach. Next paragraph. Although agencies must be able to change to meet new conditions arising within their sphere of authority, any expansion of agency jurisdiction must come from Congress and not the agency itself. Bottom of page 4. If Congress had intended the more circumscribed approach espoused by the Court of Appeals, there would have been some positive sign that the law was not to reach organized criminal activities that give rise to the concerns about infiltration. I'm at the top of page 5. The language of the statute, however, the most reliable evidence of its intent, reveals that Congress opted for a far broader definition. Next one, the statutory definition of the term statement was intended by Congress to describe material that could be fairly used to impeach the testimony of witnesses. A major purpose of the statute was to exclude from that definition various kinds of materials. Next paragraph. The statutory definition of the term cost does not include attorney's fees. Acceptance of petitioner's argument would require us to ascribe to Congress a purpose to vary the meaning of that term without either statutory language or legislative history to support the unusual construction. So we gather from all this, and I'm going to stop reading these verbatim, a statutory definition means what the heck it says it means, even if it uses the term includes. Meese versus Keene, 1987. So when I encounter a definition, I'm going to look at it and ask myself, does this include me? Is there congressional intent manifest that Congress intended it to apply to me or to implicate me in its language? Page number 6. Homes that do not meet the definition may not be licensed. And then there's a repeat of Meese versus Keene right there. We see paragraph 212. This is much further on in the memorandum than the first mention of Meese versus Keene. I'm on page 6, paragraph 2.13. Tax Code chapters 2 and 21 are not examined as proof that Americans owe no income taxes, but rather only as proof that Americans do not owe the income taxes imposed by the terms of those two specific chapters. In the past, when the argument was made that Social Security, that's not Chapter 1 of the Tax Code, when the challenge was made that Social Security did not apply to the litigant, they said, oh, he makes the argument that Social Security doesn't apply to America, or that the income taxes don't apply to Americans. No, I'm talking about Social Security. This paragraph was alluding to that particular decision when it obviously corrects the decision when it says, Tax Code chapters 2 and 21 are not examined as proof that Americans owe no income taxes, but rather only as proof that Americans don't owe the income taxes imposed by those two chapters, separating them from Chapter 1. Page 7. I claim Social Security only applies to citizens of the possessions. I'll be Chapter 1, but I'm not going to be Chapters 2 and 21. That's Social Security. They only apply to the possessions. How do you know that? Well, I got a statute at the top of page 7 that says so. Cross-references. For taxes imposed in the possessions, see Chapters 2 and 21. That's a good start. 7701A, 9 and 10. When used in this title, were not otherwise distinctly expressed or manifestly incompatible with the intent thereof. Just give me a definition, would ya? What does that even mean? That's room for the judges to run. Right there. What are you trying to say? They're not saying anything. They just threw these in there so they could be used as a tool, but when times get tough, the courts can run from them. Look at number 10. The term state shall be construed to include Columbia. Well, it uses the term include, so it includes everybody, according to the government, when we know it's a definition. The term definition, by definition, means you've just stated everywhere this definition applies to, whether it uses includes or not. But they say this applies to everybody. Look at the note right under that. Note, under this definition, Alaska and Hawaii were removed from applicability upon receiving freely associated compact state status. When Alaska became a state, Congress said, oh, they're no longer included in 7701A10. When Hawaii became a state, Congress said the same thing. They're no longer included in 7701A10. So arguably, when they say citizens of the United States owe this tax, you're not talking about the 50 states when you say United States, are you? Because states are excluded when they become a state of the Union. They'll never talk about that. It's another one of the secret statutes. Paragraph 2.16, Congress says that non-resident aliens to the complainant are to go to Chapter 2 for self-employment earnings. 879A2. Look at that footnote number 16. General rule. In the case of a married couple, one or both of whom are non-resident alien individuals, such community income shall be treated as follows. Trade or business income shall be treated as provided in 1402. That's Chapter 2. Chapter 1 just kicked non-resident aliens out into Chapter 2. Why would you do that? It's because Chapter 2 is Social Security. It doesn't apply to Americans, as we'll see in the statutory definition of citizen. Once again, 2.16. Congress says that non-resident aliens to the complainant, I'm a citizen of the United States in Chapter 1, people that are non-resident alien to me, have to go to Chapter 2 for self-employment earnings. It's a tax for non-U.S. citizens, while complainant is a citizen of the United States. 26 CFR 1.1-C, a mere regulation. Congress says that Social Security under Chapters 2 and 21 are the same tax imposed by 1939 Tax Code Section 3811. Go to page 8. This is one of the most telling needles in the entire haystack out of all of my research. Tax Code Section 7651, parentheses 5, parentheses capital A. For the purposes of this section, the reference in Section 28A of the Revised Organic Act of the Virgin Islands to any tax specified by Section 3811 of the Internal Revenue Code shall be deemed to refer to any tax imposed by Chapters 2 or 21. This just told me that when I'm in the Virgin Islands looking at their Revised Organic Act and it refers to a Section 3811 income tax, it really means Chapters 2 and 21. At first I thought, let's go to Section 3811. So I went to 3811. It doesn't exist, and then it hit me. The Virgin Islands have been around as a U.S. possession longer than the 1954 rewrite of the 1939 tax code. So I went back to the 1939 tax code, Section 3811. You see it right there. Collection of taxes in Puerto Rico and the Virgin Islands. A, Puerto Rico, B, Virgin Islands. In 1954, they split that statute up into Chapters 2 and 21. Look at the note at the top of page 8 there. It says note 7651, parentheses 5, parentheses capital A, became subsection 4 through an amendment in 2007. My briefing was filed with Congress 2006. Since then, the statute was amended, and now subsection 4 reads exactly like that. It's no longer 5A. 2.17, I'm still on page 8. 2.17, there's an abundance of evidence that complainant, that's me, that I cannot be both citizens, the U.S. citizen in Chapter 1 and the citizen liable for or eligible for Social Security. Complainant must meet the statutory definition of citizen in 26 U.S.C. Chapters 2 and 21 to be liable for Social Security. Right? Quote, thus, Congress did not reach every transaction in which an investor actually relies on inside information. A person avoids liability if he does not meet the statutory definition. I already quoted this case, didn't I? I already quoted this one too. It is axiomatic that the statutory definition of the term excludes unstated meanings of that term. End quote. Footnote 19, Meese versus Keene. And then, quote, however severe the consequences, Jay versus Boyd. And now I go on to page 9. The remaining The remaining operative chapter is Chapter 1 of the Tax Code, where Americans, citizens of the United States as asserted by the government, are implicated solely through 26 CFR 1.1-1's reference to such citizens, when Section 1, implemented thereby, makes no reference whatsoever to any citizenship of any kind. The regulation is void. 2.19. In the Tax Code, Congress has indeed named a subject of the tax or procedure in other commonly applied chapters or portions of the tax code statutory scheme, such as in its Chapter 2, Social Security Self-Employed. Here's the definition of citizen. Is this me? I'm a citizen of the United States. 1402B. An individual who is not a citizen of the United States. Well, that was easy. An individual who is not a citizen of the United States. Remember, I'm not here so much to prove who the tax applies to. I'm here to prove it doesn't apply to me. That's all. And then they go on to name as subjects, of course, citizens of the possessions. When they say this person shall not, for the purpose of this chapter, be considered to be a non-resident alien individual. Well, if you're not a non-resident alien individual, you're a resident citizen, aren't you? So for the purposes of this chapter, this person is to be considered a resident citizen. He is not to be considered a non-resident alien. Now look at the regulation that implements that statute. Fascinating. A non-resident alien will never owe, he never has, self-employment income, while a non-resident alien individual who derives income from a trade or business, and I know about the definition of that, carried on within the United States, the possessions, he may be subject to the applicable income tax provisions on such income. Such non-resident alien individual will not be subject to the tax on self-employment income in Chapter 2, since any net earnings which he may have do not constitute self-employment income. For the purposes of the tax on self-employment income, which is Chapter 2, an individual who is not a citizen of the United States but who is a resident of the Commonwealth of Puerto Rico, Virgin Islands, Guam, or American Samoa is not considered to be a non-resident alien individual. So from the top, a non-resident alien never has self-employment income. Well, we know that a citizen of the possessions is not a non-resident alien in this chapter. He is the resident citizen. And it says here, while a non-resident alien may be subject to income tax provisions, he won't be subject to the tax on self-employment income. Well, I got news for you. The only other chapter in the tax code that addresses the self-employed is Chapter 1. Now I have a Chapter 2 provision that kicks a Chapter 1, or kicks a non-resident alien out into Chapter 1. and I have a Chapter 1 provision that kicks a non-resident alien out into Chapter 2. You can't be both citizens. Wasn't that easy? I'm not subject to Chapter 2. It's for the possessions only. I'm a non-resident alien to those chapters because I'm a citizen of the United States. Page 9, bottom of the page, 3121E. This is the definition of citizen from Chapter 21. Before we go on, notice that in 1402B, it doesn't use the term includes. And so they can't say, oh, it includes everybody. Can't say that. Bottom of page 9, 3121E. An individual who is a citizen of the Commonwealth of Puerto Rico, but not otherwise a citizen of the United States. Well, that's not me. 3121 is called definitions. If it talks about citizenship, it's going to define citizenship. That's not me. Page 10. Regulations. 26 CFR 31.0.0. That means it's not even written under a statute. There's a preliminary, I want to say chapter, a preliminary segment of Part 31 of the CFR that is not written under particular statutes. It's more an introductory set of regulations. 26 CFR 31.0-2A1. The terms defined in the provisions of law contained in the regulations in this part, Part 31, shall have the meaning so assigned to them. 26 CFR 31.3121E-1B. This is the implementing regulation for the definition of citizen, and it does use the term includes. Why would they put includes in there when the statutory definition doesn't use includes? Because they need to stretch it out of shape. And so they put includes in the regulation that implements the definition of citizen in Chapter 21. What is includes doing there? Well, we needed to put it in the regulation so we could stretch the statute out of shape. Includes is one of our biggest tools to stretch a definition out of shape. The term citizen of the United States includes a citizen of the Commonwealth of Puerto Rico, American Samoa, and effective 1961, Puerto Rico or Virgin Islands, and effective in 1961, Guam or American Samoa. Doesn't include me. Well, it includes everybody. It uses the term includes. Well, that's not in the statute, is it? They had to have the term includes in there somewhere. Holy smokes, what are we going to do so we can double tax citizens of the United States? Moving on, 42 USC 411B2, Title 42, where they administer Social Security benefits. And I have the same definition of citizen as we had in 1402B in the tax code. An individual who is not a citizen of the United States, but who is a resident of Puerto Rico, Virgin Islands, Guam, or American Samoa, shall not, for the purposes of this subsection, which is a definition for the purposes of this chapter, be considered to be a non-resident alien individual. He shall be considered the resident citizen. Wasn't that easy? Everywhere you go, looking at Social Security, you find this constraint. Moving on, and in Tax Code Chapter 24, Congress has named a subject of the W-4 form, employee. Everybody has been over and over this definition, and they all key on the term includes when in fact Meese versus Keene, 1987, interprets a statutory definition of political propaganda that uses the term includes as a definition that is restricted in scope to the things that it mentions. Moving on, page 10. In those chapters referenced above, all subjects of these taxes were found in statutes called definitions, 3121 and 1402. But in Chapter 1 of the Tax Code, we find no section called definitions, which even remotely mentions a subject or citizen, as we found so clearly identified in these other chapters. These definitions are merely a simple expression or exercise of the power conferred upon Congress by the U.S. Constitution Amendment 16, to wit, The Congress shall have the power to lay and collect taxes on incomes from whatever source derived without apportionment among the several states and without regard to any census or enumeration. And here, quoting Commissioner versus Acre, but the section contains nothing to that effect, and therefore to uphold the Commissioner's addition to the tax would be to hold that it may be imposed by regulation, which of course the law does not permit. And he cites, the Supreme Court cites US versus Calamaro. That's the case that I opened with in this exercise. Paragraph 2.22. Again, while Congress has clearly identified a subject in chapters of the tax code which impose taxes which clearly do not pertain to the complainant, me, but rather apply to people with other citizenships and occupations in their income, Congress has at the same time never identified a subject citizen in Chapter 1, the complainant's citizenship finding its sole mention in regulation alone, 26 CFR 1.1-1 A, B, and C. This regulation is not the work or intent of Congress. Congress has never named the complainant, purportedly a citizen of the United States, as subject to any tax imposed under the provisions of 26 U.S.C. See Brown & Williamson Tobacco Company versus FDA. The FDA stripped of tobacco enforcement authority for lack of a statutory basis. Page 12. Here's the regulation. 26 CFR. Before they wrote this regulation, you look at the tax code. Boss, Americans aren't subject to Chapter 21, or Chapter 21, FICA. Well, write a regulation under that definition of citizen that uses the term includes so we can broaden that. But boss, they aren't subject to Chapter 2, Social Security self-employed. Well, lose the definition in that regulation to say, oh, the non-resident alien will never owe this tax, but he might owe some other tax, when the only other tax on self-employed is Chapter 1. Boss, in Chapter 1, Congress hasn't named a subject. Write me a regulation under Section 1 where we have the individual, or the progressive income tax for married individuals, finally jointly, separately, head of household, surviving spouse, and single individual, capital gains. And so they wrote this regulation. General rule, top of page 12. General rule. Section 1 of the code imposes an income tax on the income of every individual who is a citizen or resident of the United States. Who says so? Section 1 only alludes to single individuals and married individuals. Citizenship is not mentioned. B. Citizens of the United States or residents liable to tax. In general, all citizens of the United States, wherever they reside, wherever resident, and all resident alien individuals are liable to the income taxes imposed by the code, whether the income is received from sources within or without the United States. C. Who is a citizen? Every person born or naturalized in the United States and subject to its jurisdiction is a citizen. Nowhere do you find in Section 1 of the tax code a reference to citizenship. Paragraph 2.23. Only Congress can impose an income tax, inasmuch as citizens of the United States are named as subjects of 26 U.S.C. only in regulation, 26 CFR 1.1-1, and defendant's application of 26 U.S.C. to the complainant, me, is therefore in violation of the 16th Amendment to the U.S. Constitution. The term defendants refers to the people that I named as criminals in the original complaint to Congress. The Secretary of the Treasury, Commissioner of IRS, Tax Court Chief Judge, U.S. Attorney General, a couple of U.S. District Judges, a couple of Assistant U.S. Attorneys, and an IRS agent. And this would explain why, paragraph 2.24, Congress has chosen to expressly require that every office of the federal government receive congressional permission to operate outside of Washington, D.C. Title IV, Section 72. All offices attached to the seat of government shall be exercised in the District of Columbia and not elsewhere, except as otherwise expressly provided by law. Well, we pretty much just explained why the Secretary of the Treasury and IRS can't answer to that statute. They don't have a statute that allows the tax code outside of D.C. in the possessions. Wasn't that easy? Paragraph 2.26, as if it wasn't bad enough already. If Congress had intended the income of Americans to be taxed, it would have named them as subjects as it has in other chapters, like in Section 1402B, 3121E of the Tax Code, and 42 U.S.C. 411B2, and the Social Security Act, Section 211 from 1935. Go to page 13. And it would not have officially excluded the states from the definition of state as soon as they became a state. Where is the statute that says, I'm at the top of page 13, where is the statute that says, for the purposes of this chapter, any person born or naturalized in the United States and subject to its jurisdiction shall be considered to be a citizen of the United States? Where's that statute? That's the statute that would make Americans liable. It doesn't exist. Paragraph 2.27, there simply is no such provision from Congress. Only 1.1-1 from the Secretary of the Treasury. This issue and the challenge to the office of the Secretary of the Treasury under Title IV, Section 72 are those briefed at page 17 through 23, paragraph 4.5 to 4.19 of the Congressional Complaints Memorandum filed in 2006, and each include questions that must be addressed and answered if the claims are deemed invalid. There were questions presented for review under each of those briefed issues. 2.30, just as in Brown versus Williamson, agency authority to promulgate regulations has led to derogation, giving rise to new authority to impose income taxes in violation of the 16th Amendment. Here's tonight's lesson. Paragraph 2.31. Below is a compilation of quotes from decisions which either cite or directly involve Regulation 1.1-1. However, none of these decisions concern or relate to the argument presented in this case. 26 CFR 1.1-1 is in derogation of statute when it identifies a political subject or citizen of the income taxes, that the 16th Amendment is violated by the fact that this regulation serves to name the subject of the income taxes imposed under Chapter 1 of the Tax Code, whereas statute does nothing of the sort. Below, there's going to be a compilation of cases that cite or involve Treasury Regulation 1.1-1, but in none of those cases was the challenge made. It's just a regulation. And you're going to see that the courts rely heavily on the fact that regulation names Americans as subject. Bottom of page 13, 2.32. Nowhere in Section 1 does Congress allude in any way to any individual of a particular citizenship as it did in Chapters 2 and 21, in 1402B and 3121E, which expressly exclude citizens of the United States. It would be just as, page 14, it would be just as easy and as constructively sound to write a 26 CFR 1.1-1 that contains the definition of citizen from Chapters 2 and 21 instead of implicating U.S. citizens. 2.33. After all, Chapter 1 provisions are to be used to calculate Chapter 2 liabilities according to 1.1402A-1A1 and 1402A-2A, which say gross income and deductions of Social Security self-employed are to be determined by reference to the provisions applicable with respect to the taxes imposed by Sections 1 and 3 in Chapter 1. And Chapter 1, Section 83 applies to all wages which should include Chapter 2 self-employment earnings and FICA wages in Chapter 21. What I just did there, I stated that this regulation that identifies Americans could just as easily be written to apply only to the statutory definition of citizen in those other chapters, because as we see, Chapter 1 provisions are supposed to be used to figure those taxes. So Section number 1 could just as easily be relevant or applicable only to those citizens. How come you had to write a regulation that identifies a subject? And then it revisits 7701A, 9, and 10. And states again that, see, as soon as Hawaii and Alaska became states, they were excluded. Page 14, bottom paragraph, 2.35. In light of this fact, how can this definition of United States or the reference in 26 CFR 1.1-1 of United States be construed to include any of the compact states? Great question. Page 15. 2.36. In citing the decisions below, CA shall be deemed to mean Court of Appeals, followed by the number of the circuit on which the case was decided. Cases cited as Federal Appendix are unpublished decisions, as are those marked as unpublished. And we see in circuit after circuit, district court after district court, that in all these arguments, look at the first one, CA1, that's Court of Appeals 1. Metallic versus Commissioner of Internal Revenue. Metallic acknowledges that he resides in this country, and so the tax laws apply to him even if he is not a citizen. Noting that the tax code imposes a tax on the income of every individual who is a citizen or resident of the United States. So he goes down in flames. He claimed not to be subject. They said, yes, you are. And what did they point to? 1.1-1. US versus Benita Retzach. I have no idea how to pronounce that. The tax regulations of the United States generally provide that citizens of the United States are liable to pay income tax even if they are not residents of the United States and own no assets or receive no income in the United States. How do we know? Well, you see this regulation, 1.1-1. The regulation's doing the heavy lifting. A citizen is defined by the regulation as a person born or naturalized in the United States and who is subject to its jurisdiction. Such a definition must be made under the Immigration and Naturalization Act. And they cite 1.1-1. Bottom of page 15, Roe versus IRS. Quoting IRS's memorandum, despite Roe's attempt to avoid federal income tax liabilities, if Roe is a citizen of Maine, she is a citizen of the United States, and even citizenship is not prerequisite for tax liability, as the Internal Revenue laws apply not only to citizens, but also to residents. How do we know? Oh, we have this regulation. The tax code imposes an income tax on the income of every individual who is a citizen or resident of the United States. How do we know? Well, we have a regulation. The regulation does the heavy lifting. We're just getting started. This is page 15 of 26. Page 16. It's well established that it extends to all residents and citizens, citing 1.1-1. Court of Appeals, Second Circuit, Estate of Pechek versus Commissioner. In the period prior to the abandonment of citizenship, the individual is taxed as a non-resident citizen. Generally, a non-resident U.S. citizen, United States citizen, is taxed on his worldwide income. How do we know? Oh, we got this regulation. It's magic. That regulation just keeps popping up and popping up and popping up. Whenever somebody says, hey, I don't owe this tax, I'm not an American, or it doesn't apply to Americans. CA3, or Court of Appeals 3rd, U.S. versus Sikloff. unpublished, 2011. To start, Sikloff is clearly obliged to pay taxes as a citizen of the United States. How do we know? We got a regulation. All citizens of the United States, wherever resident, are liable to the income taxes imposed by the Code. CA3 District Court, US versus Lasonic. We note parenthetically that Section 1 imposes an income tax on the income of every United States citizen, and that pursuant to Section 1A and the regulation provides that all citizens of the United States are liable to the income taxes imposed by the Code. Fourth Circuit District Court. The source rule of Section 861 through 865 do not, as defendant argues, exclude from U.S. taxation income earned by U.S. citizens from sources within the United States. Page 17. It imposes an income tax on the income of every individual who is a citizen or resident of the United States, and Section 61 defines gross income. How do we know? Oh, we have a regulation, and there's the regulation at the end of that paragraph. Fifth Circuit, Thomason versus Commissioner of Internal Revenue, and I'm on page 17. And here he argues the 861 argument. It has been universally discredited, and they cite cases. In general, all citizens of the United States are liable to the income taxes imposed by the Code, whether the income is received from sources within or without the United States. See Rayner versus Commissioner, quoting Treasury Regulation 1.1-1. Rayner versus Commissioner of Internal Revenue. All citizens of the United States owe this tax. How do we know? We've got Treasury Regulation 1.1-1. Court of Appeals, Sixth Circuit, bottom of page 17. Third, Van Manen's jurisdictional argument is unavailing. It is a well-established principle that the taxing power of the United States of America extends to every individual who is a citizen of this nation. How do you know? Oh, we got a regulation. 1.1-1. Page 18. Sinelli versus Commissioner of Internal Revenue. The United States taxes all income of its citizens, whether earned here or abroad. How do we know? Oh, we got this regulation. Sixth Circuit District Court, U.S. versus Gruters. As to whether the United States has jurisdiction to impose income taxes on the Gruters, 26 U.S.C. Section 1 imposes an income tax on the income of every individual who is a citizen or resident of the United States, and to the extent provided by Section 871B or 877B on the income of a non-resident alien individual. How do we know? Oh, we got this regulation, 1.1-1. Magic. Are you learning anything? The regulation does the heavy lifting. The statute says nothing about citizenship. Court of Appeals, Seventh Circuit, U.S. versus Vallone. Vallone wrote a letter to the IRS in which he made a variety of baseless claims, including the assertions that he enjoyed certain rights unique to a sovereign citizen born in the United States, that he was neither a citizen nor resident of the United States as those terms are used in the 14th Amendment, or 1.1-1. The IRS regulation identifying those persons who are subject to the income tax. Right there, the judge says the regulation identifies the people who are subject. Thanks. That's the argument I'm making. It's just a regulation. And in none of these cases did anybody say that. Court of Appeals, 8th Circuit, bottom of page 18. The district court had jurisdiction because the Langers conceded they were domiciled in Nebraska, and the federal income tax applies to residents as well as citizens. How do we know? We got a regulation that says so. Page 19. Daggett versus U.S. Nebraska. Section 1 of the Internal Revenue Code imposes an income tax on the income of every individual who is a citizen of the United States. 1.1-1. Ninth Circuit. I'm on page 19. Bates versus Commissioner. The contention that the Bates were not subject to the federal income taxes is frivolous. See US versus Nelson in re Beecraft, Treasury Regulation 1.1-1. Arnstein versus US. Therefore, money seized from him was not taxes. This argument lacks merit. See 1.1-1. Section 1 of the Code imposes an income tax on the income of every individual who's a citizen. Rintoul versus Commissioner. The Internal Revenue Code defines taxpayer as any person subject to any internal revenue tax. Every individual who is a citizen or resident of the United States is subject to income taxation. Section 1 and Regulation 1.1-1. You get the idea, but I can't say enough about this. Peckrell versus Commissioner of Internal Revenue. They claim instead that they are non-resident aliens whose income is not taxable. As did the tax court, we reject this frivolous argument because the Peckrells clearly are taxpayers whose wages are subject to federal income tax. See the 16th Amendment, Section 1, and Regulation 1.1-1. Grammatico versus Commissioner. First, the Grammaticos are taxpayers whose wages are subject to federal income tax. See the 16th Amendment, Section 1, and Regulation 1.1-1. Top of page 20. Smith versus Commissioner. First, the Smiths are taxpayers whose wages are subject to the federal income tax. See the 16th Amendment, Section 1, and 1.1-1. Notice how the Ninth Circuit is including the 16th Amendment and Section 1, whereas prior to this we saw plenty of cases that cited only the regulation. Sharon versus Commissioner. First, Sharon's wages are not exempt from federal income tax. See the 16th Amendment, granting Congress authority to collect income tax. Section 1, C, individual citizens are subject to the federal income tax. Regulation 1.1-1. Section 1 of the Code imposes a federal income tax. Brayton versus Commissioner. Every individual United States citizen is subject to the income tax. See Section 1 and 1.1-1. Despain. The Commissioner, however, is statutorily authorized to impose an income tax on individuals, such as Despain, who are a United States citizen. See Section 1C, unmarried individuals, and 1.1-1, every citizen of the United States. US versus White. The IRS is statutorily authorized to impose an income tax on United States citizens who reside in the United States and whose income is derived from domestic sources, which is really a mistaken language to a degree. The IRS does not have the authority to impose a tax. It has the authority to determine the amount of liability for taxes that Congress has imposed. Slight misspeak, no big deal. Page 21, 10th Circuit. The very first section of the Internal Revenue Code, Section 1, imposes an income tax on the taxable income of every citizen or resident of the United States. 1.1-1. Gallegos versus Commissioner. All citizens of the United States are liable, every person born or naturalized. See 1.1-1, A, B, and C. Cox. All citizens of the United States are liable. 1.1-1. Benson. It is well established that Mr. Ambort, a United States citizen born in California and living in the United States, is subject to the tax laws. 1.1-1. US versus Smith. The very section of the Internal Revenue Code, Section 1, imposes income tax liability on every citizen. See 1.1-1. And US versus Gonzalez. All United States citizens and resident aliens must pay federal income tax. 1.1-1. The regulation is doing the heavy lifting across the board. Page 22, 11th Circuit. Ahmed versus Commissioner. 1.1-1. Langill. Rote, Wright versus U.S. and Internal Revenue Service, Hovind versus U.S. They all say, I'm not a citizen of the United States. I don't live in the United States. I'm a non-resident alien. Wrong, and therefore you owe the tax. See 1.1-1. D.C. Circuit, I'm at the top of page 23. They go on. And that regulation is cited everywhere they go, when in fact if you look at the statute, you don't find them identifying citizens of the United States as a subject. So going back to the beginning of the lesson, I'll be a citizen of the United States if you say I am, but just long enough to tell you, excuse me, that's a regulation. Do you have any statutes? 2.38, we should note first, U.S. Supreme Court. The challenge was not made to this regulation, that it's just a regulation. And so the Supreme Court in 2003, Demore versus Kim, unlike temporary non-immigrant aliens who are generally taxed only on income from domestic sources or connected with a domestic business, LPRs like citizens are taxed on their whole worldwide income. See 1.1-1. So even the Supreme Court cites that regulation. Page 23, paragraph 2.38. Were the courts that rendered the above decisions to point to 26 U.S.C. 1 without reference to 1.1-1, one who reads the decisions is left with a question as to where, in Section 1, is there any reference at all to anyone's citizenship. Regulation 1.1-1 is rife with such intent, while statute is barren of any such language. 26 U.S.C. Section 1 were to stand alone, without the regulation 1.1-1 promulgated thereunder, it is impossible to assign the statute's operation to more than the individual referenced in the many brackets therein. When the tax code identifies the subject, next page, page 24, of a tax by defining the term citizen, Congress identifies the subject of the tax by identifying a citizen, as it did in 1402B and 3121E. Were it not for the promulgation of this regulation, the tax code could not be understood to have laid an income tax on Americans. So to do so is a violation of the 16th Amendment, which authorizes only Congress to lay and collect taxes on incomes, precisely as briefed in the memo of January 2006, supplemented herewith. This is a supplemental briefing of that January 1st, 2006 complaint. And now we get to questions presented for review. If I'm wrong, answer these questions. And I mean yesterday. I want answers to this. I'm not claiming to be a non-resident alien. And I want you to get into how Section 1 carries gravity, statutory language, that gets Americans into that graduated income tax. Before we go on, note, and this is so vitally important, what I first proved was that Social Security has always been theft. American. They've always stolen Social Security. It's been double chapter taxation. They spent the money. They print money like it's free. And they didn't save the money. They didn't spend the money on the elderly. They didn't spend the money on the homeless or on the vets. They spent the money on aircraft carriers and depleted uranium ammunition and tanks and Tomahawk missiles so they could parade around the globe, cornering the market on oil and gold, lithium, silver. The resources that our government is chasing, they chase with machinery they bought by stealing from 300 plus million gun owners. Social Security has always been theft. Even if we were subject to Chapter 1 of the tax code, what I first proved was that Social Security has always been theft. And I did it with a mountain of statutory evidence, not just those two definitions in Chapters 2 and 21. I did the work. The Social Security Act of 1935, Section 211, 42 U.S.C. 411B2, Section 3811 of the 1939 Tax Code, and Tax Code Section 7651, parentheses 5, parentheses A, which is now simply subsection parentheses 4. I looked at all these statutes. I took the time to analyze them for their meaning, and I've got a mountain of proof. Social Security has always been theft. It's never applied to Americans, but those who would impose a 25-pound tax code and regulations on Americans simply had to have all that money coming in because they had plans, and none of their plans included America's elderly. They spent the money, and Social Security is broke unless they keep printing money based on nothing. So Social Security has always been theft, period. And they spent the money. Do you think a government like that is ever going to let you volunteer out of something? Do you think it's a legitimate contract that has you liable for any of this? And I'm talking to the Patriot movement. You got to be kidding. You have to spare me all these harebrained notions coming out of especially the one, income tax is collected through voluntary compliance. Compliance with what? There's no tax to volunteer into. Volunteer into what you pay the government. It has to be called a gift because it's not imposed by law. And adhesion contract, all of these are presumptions that enforcement is legitimate. And so, since they have this authority over me, I must have assessed myself. I must have signed an adhesion contract. Oh, I got a Social Security card. I used the zip code. All these harebrained notions, you have to come to realize they're all they're presumptions, based on the first presumption, which is incorrect, that enforcement is legitimate. You start with the law first. If you'd have taken the time to analyze the chapters that impose the taxes, and first crossed that hurdle, you'd have ended up right where I am with this argument. Chapter 24 doesn't even impose a tax. Screw the W-4 form. I need to talk about the chapters that impose taxes. They collect chapters 1, 2, and 21 off of me. Chapters 2 and 21, it's the same tax, Social Security. I don't owe it. Which means also, and I usually forget to say this, Section 3111 is the statute that imposes matching FICA on your pay that your company has to pay. Your employer, they got to pay 7% of the wages they pay you, you got to pay 7%. So out of all of the wages paid to employees, 14% goes to the government. Hey, we're going to raise the minimum wage. Why? Well, because the government needs more money. They call that the payroll tax. It's Social Security, imposed by Section 3101, and the employer pays matching FICA under 3111. It's always been theft. Social Security has never applied to Americans. And I did the work. I didn't look at the tax code through a keyhole. I looked very broadly at the tax code and picked it apart for individual small indicators everywhere where they mentioned any statute that's in chapters 2 and 21. Everywhere they referenced chapters 2 or 21. Everywhere they mentioned the term Social Security. I read up on it and read up on it until I understood enough about it to see whether or not it backed me up in my allegation that those chapters only applied to people that did not have my citizenship. If I'm a citizen of the United States, I can't be Social Security unless you screw me out of the definition of citizen in those chapters. I'm on page 24. We're going to get to the conclusion. Paragraph 3.1. The burden is squarely upon the defendants to identify the legitimate promulgation which does not create an application or requirement lacking clear statutory foundation. In light of the above discussion, we cannot but regard this Treasury regulation as no more than an attempted addition to the statute of something which is not there. Page 25, citing Calamaro. That's the case I began with. But the section contains nothing to that effect, and therefore to uphold the Commissioner's addition to the tax would be to hold that it may be imposed by regulation, which of course the law does not permit. Commissioner versus Aker. The void for vagueness doctrine is a tenet of due process. In this particular case, look at the underline where they're citing a 1911 state case. When the tax gatherer puts his finger on the citizen, he must also put his finger on the law permitting it. And this is a U.S. Supreme Court case from 2001, citing other cases. Page 26. This is Evans versus Gore, the top paragraph. The executive not only dispenses the honors, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, to the contrary, has no influence over either the sword or the purse, no direction either of the strength or the wealth of the society, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment. Great paragraph. It is, of course, true that Supreme Court decisions are on occasion overruled, and that the opportunity to overrule them would never arise if litigants did not continue to challenge their validity. But in this context, at least, it is unnecessary to penalize the United States' proper reliance on our past decisions in order to re-examine them, since there is no bar to a suit by plaintiffs below directly against Oklahoma for recovery of the tax. And if the doctrine of stare decisis has any meaning at all, it requires that people in their everyday affairs be able to rely on our decisions and not be needlessly penalized for such reliance. In closing, key to the code. The argument I've just outlined for you stays within statute to show you that in statute there's no reason to believe an American is subject to any of these taxes. Chapters 1, 2, and 21. Only in regulation is an American named as a subject by citizenship, which is how Congress does it. We saw that in chapters 2 and 21, that Congress will name a subject of the tax by identifying a citizenship. They didn't do that in chapter 1, but regulation does. And I went on to show you on a circuit-by-circuit basis that there's a multitude of cases that cite that regulation as the authority. It does the heavy lifting. They don't go anywhere without that regulation. If they cite Section 1, they cite that regulation right beside it. It's just a regulation. The 16th Amendment says Congress can lay and collect this tax. It has to be a statute. My allegation is that this tax is imposed by regulation in violation of the 16th Amendment that authorizes only Congress to lay and collect an income tax, and that Social Security has always been theft. It's never applied to Americans. My name's David Merlin. This has been Key to the Code, part of the Codebreaker curriculum, the single most heavy lifting argument of all the conclusions briefed. It went to Congress 2006. It's been everywhere ever since. It's been injected into several proceedings. It has terminated a couple of grand jury proceedings. It has shut down the Criminal Investigations Division of the Internal Revenue Service several times. And scrolling past page 26, tab number 8, this was exhibit number 1 to Congress in 2006, and there you see the docket number. Mr. Walden called me up in March of 2005 and said, I think I might be indicted for failure to file. Any ideas? I just heard your name, never heard of you before. I heard you do good work. And the first thing I told him is, how would you like an exhibit that proves you sued the United States for proof that the tax code applies to Americans and they can't debate you on 3 or 4 statutes? He said, let's go for it. So I wrote up a Rule 27 civil suit, action to perpetuate testimony, which only gets you discovery rights. You don't have to state a claim. You're not suing for money damages or declaratory judgment. And the brief that was attached to the complaint had questions for review under this issue that was briefed, along with 2 other issues briefed. Another one of the issues was Title IV, Section 72. 12 questions altogether, 3, 4, and 5 questions under issues A, B, and C, 12 questions. And instead of disproving this brief, Assistant U.S. Attorney Stephen Bass asked the court for a protective order against having to answer the questions. Will the court please issue an order prohibiting Mr. Walden from asking me these questions? Going to the next page, there's the protective order that Judge Lee Yeakel issued in Austin, U.S. District Court, Austin, Texas. This stunt got Judge Lee Yeakel and Assistant U.S. Attorney Stephen Bass named as defendants in the complaint I filed with 80 members of Congress. Why would you need a protective order against the argument? You're the big bad United States, the biggest legal department in the world. And when they face this briefing of the tax code, I'm only named in a regulation, they need a protective order against having to respond to it. There's the actual document. It's the first document that came out of the court, and this was the exhibit I promised him, that he sued the United States for proof that the tax code applies to Americans and they can't even debate him on 3 or 4 statutes. Another thing you see, I hope you realize in this lesson, is that I'm backing up everything I say. I've got a multitude of case law that wield that regulation like it was law. And I relied strictly on statute. And I showed you the language of all those statutes. And the U.S. needs a protective order. This was Exhibit A, the first exhibit to Congress. And when this goes to a grand jury or to the Criminal Investigations Division of the Internal Revenue Service, in probably about a dozen instances, maybe more, the investigation has been shut down or the grand jury does not return an indictment. I think that's a real good note to conclude the lesson on. My name is David Merlin. This is Codebreaker. None of this is legal advice. Thank you for visiting Take from Caesar on YouTube. For more information and materials, you always want to check to see if there's something new at takefromcaesar.us. See you in the next lesson.